Before we get started, any questions or anything? Any insights into special education law that that just blew your mind in doing the readings for this week?
I think it was a good reminder.
A good reminder
Of some stuff that might not always be on the forefront of our minds when we're in the classroom making decisions.
Right, because making the wrong decision for the wrong student, with parents who are kind of informed in this material, can certainly lead to, much difficulty and challenge.
Yeah.
So it's definitely important to, clearly, we're not going to come away from this class having mastered every facet of IDEA and every facet of Section 504 of the Rehabilitation Act. But at least we're going to know where to go to look for information in the case that we do need it. If we hear something that's happening in the classroom that, doesn't sit right, hopefully this class is going to kind of give you that light bulb. It's going to turn on that light bulb. Like, wait a minute, I read something about, this situation and what's occurring here that does not seem like it's in compliance with the law.
I've got a question for you. The 504 that we keep talking about, did that lead to the 504 that we have kids on nowadays?
Absolutely. Section 504 of the Rehabilitation Act of 1973. Yeah, that is why we have a 504 plan today in special education. And so Section 504 does not only cover school, it covers, kind of other settings in the community as well.
Well, it helps cover like private.
Exactly. The workplace, just public access to buildings that receive, basically anything that receives any kind of federal aid is held, under the requirements set forth in, whatever section of the 504 is relevant to it.
Chapter 9 was really helpful because I've heard of students being on a 504 plan,
Yes.
but I've never experienced it. I've never had that in my classroom. It's kind of interesting.
Yeah, so certainly there are a lot of similarities, but there are some big differences as well.
Yeah, I liked how clear Chapter 9 was on those. Because I knew more about IDEA than I did the Section 504.
Right. And the Americans with Disabilities Act, which was also a focus of Chapter 9, certainly there are cases that have been tried, the plaintiffs arguing that, whatever the school district did was in violation of the ADA, but generally, most case law is related to violations of IDEA or Section 504. Because they're kind of more specifically focused on the educational sector and on public schooling. Colby, did you have another comment?
My son was on an IEP, and then I moved him from an IEP to a 504, and then last year had to file a formal complaint on his 504, so that became interesting.
So
with his 504 not being met.
Was it your choice to move him, or was it because of an evaluation determined that he was no longer qualified for services under IDEA?
He was still qualified. We went to Australia and did a study abroad program for a year, and before we left, they needed to have tested him, and they didn't, and so they tried to test him like the weekend before we left, and I was like, we're not going to do this weekend before we leave. And in Australia, he was able to completely go to school because they don't have IEPs in Australia. Mm-hmm. So he was able to completely function and be okay. So then we thought we'd just put him on a 504 to carry on into college because he's a senior this year.
And it was successful?
Depends on he's in a new school now, and it seems to be going much better.
Okay. Right. Yeah, generally the 504 is kind of less hands-on, I would say, than the IDEA, right? Like the requirements set forth in the IDEA are much more strict, whereas the 504, and we'll talk about it, in a bit more depth, but like 504 really doesn't even talk about like specific disability categories that are required. It's all about impairments that kind of get in the way of major life activities. And certainly a lot of disabilities covered by IDEA will, present barriers or challenges to major life activities, but they're not like specifically named within it.
Can't someone that like recently broke their leg be put on a temporary Section 504?
Yeah, like
I've heard
a physical impairment. They're even mentioned cosmetic impairments, right? In like when you read all the fine print. Yeah.
I had
Basically. Oh, go ahead.
No, it was along the same lines, but it wasn't about that.
Okay.
Sorry.
Oh no, go.
I had used a section from 504 so last year I was in a classroom. It was kind of in the back of the school, but it wasn't like unusual. There were other classes around me.
Mm-hmm.
And there were a lot of complaints from gen ed teachers that the behavior students were causing too much trouble and being too loud and causing too many disruptions. And they had convinced my principal to move my classroom. And they were going to put me in what used to be the orchestra room, but it's not in any of the hallways. Like it's back behind the north gym. Like you have to go through the gym and then through the storage room and then from the storage room into this classroom with no windows. And
right.
And I had written them a really long email, and I actually quoted something that was in here too that says like that it's part of 504 is that like school officials can't relocate special education classes to lesser facilities for the purpose of accommodating classes for students without disabilities. And so like I had quoted that in my email to them saying like, you can't put us, like you can move us, but you can't put us in somewhere that you don't like, that you're moving out another class because they didn't even like it. You can't just throw a bunch of students receiving special education into this closet behind the gym. And so we got a much better room. right by the office. We have this big courtyard. It's great.
Yeah, it's helpful if you can, add in those complaints, like specific language related to the, federal laws that they're violating.
Yeah, I was like,
that gets their attention.
Law, you cannot do this. I will not move into that room.
Right. Cool. Before we get started, I wanted to just share something real quick. Okay, so we're looking at our home page here. And so what I've done is this first link here. If you just click on that, it'll take you to a Google Drive folder in which I'm placing all of our recordings. So they're all there. So again, I was experiencing difficulties with YouTube. Like sometimes my video would upload, other times, it would process from 0 to 95% in like 2 minutes, and then it would get stuck on that last 5% for like an hour and a half and just wouldn't work. And I just kind of got fed up with it. So by clicking here, you'll just be taken directly to the folder wherein you'll find our recordings. So hopefully that's a bit more convenient for you all. Go ahead.
The links that were below that to the Zoom today, it said Zoom links for each day. I clicked on the 10/7 and it took me to some weird.
Did it?
Yeah, it like took me to a weird website, and then it said, "Are you looking for a Zoom code?" And it gave me a code, and then I went to zoom.com and put in the code, and then I got to the meeting. So I'm wondering if other people are having that problem, and that's why I'm not here today.
Yeah.
Mine just said it couldn't get there.
Mine just says it can't load.
Yeah, mine said no loading.
Oh, okay. Well, that is interesting. So, okay. But you do have them all on your calendars, right? So you're able to access them there?
I didn't know they were there.
So when I sent out like the initial invite for all of the meetings for this quarter, for this term, did they not go automatically onto your Google Calendar? They didn't? When you accepted them?
I don't see anything. Like the school Google Calendar, I don't see anything.
Okay, that is very strange. Because normally when I set it up, you know, I set the dates and then I use Google Calendar. I put all of your EOU email addresses in there and I send them to you.
I see the ones from last week with a Google, or sorry, there's a Google Hangouts and a Zoom link on last week's, but not this week's or anywhere else. The only events that I have are the 30th and October 1st.
Okay, that is very weird. Okay, well, I thought I was making it easier on you, but clearly I failed in that regard. So I'm gonna have to go back to the drawing board because in my previous experiences using Zoom, it has worked. So I don't know, maybe it's gonna be a matter of me just kind of resending them once a week before we meet. So I'll look into that and I apologize.
Also, that initial code works for every meeting.
Yeah.
So,
right.
Yeah, I downloaded the app and then I just type in the same code from that initial email and it just says join a meeting, type in, or just like copy paste the code and boom, there you all are.
Good. Okay, well that's probably the easiest way to do it because I did use that same code for all of these links. And so it's weird that it's not working and it's not, it's kind of taking you in this roundabout way to get to the meeting. But I'll further investigate it. Okay, let me go ahead and close some of this stuff out. So we have some law to talk about today. Okay, so certainly these, I mean, the first chapter was, I think, informative just because it kind of broke down the structure of the United States legal and judicial system, which is important because when you read through the case decisions that I have located and that I will be sending out to you for your final project, you're going to see reference to these kind of different types of courts and decisions when you read through them. So I thought it would be helpful just to kind of briefly go through some of the material that first chapter covered in regards to just kind of the structure of the legislative system in the United States. But just very briefly, let's just talk about what there was before there was such a thing as special education law. So when we talk about the time frame of, basically the beginning of time on into like the early 19th century, the majority of schools, they simply, or public schools, did not support the educational needs of students with disabilities. Does anyone have an idea of where students, for example, let's say in the late 18th century, a student had an intellectual disability or some other physical disability or, any other kind of learning difference, how might those individuals have been educated, if at all? Would they have stayed in the home, or what would have happened?
They were institutionalized, weren't they?
Right. They would often be sent to institutions. And these institutions, serve two purposes. They were, they were argued or, often parents were kind of persuaded to send their students with these disabilities to these institutions, because by doing so, the amount of stress caused by raising that child would be greatly reduced, because that child would be kind of outside of the home. And the argument being there, by reducing this kind of like major stressor, well, then there's going to be less kind of negative impact on other members of the family. So, you know, there was like a very large kind of like maintenance of kind of social harmony component going into making these decisions to institutionalize, you know, children, young adults, or, you know, adolescents, basically people with disabilities throughout their age ranges, throughout the lifespan. However, oh, go ahead.
Well, this isn't the 19th century, but the 20th. But in like the 1950s, our book said that half of our states had laws calling for the sterilization of people with disabilities.
Which is, yeah,
crazy,
terrifying.
Yeah, with laws saying that this should happen.
Right. It's all part of the eugenics movement, right? It's all based on basically a distorted version of Darwinism's, you know, theory of natural selection, right? That if we eliminate from the reproductive pool these individuals who are carrying these kind of deleterious genes and conditions, then in the long run we're going to better the condition of our human race, which certainly is not true. But we did see there. Oh, go ahead.
Could that be why the rise of your statistics of autism too? If you did have a very large sterilization program going on and there was not as much recording of autism, and then that slacks off, and then could that come into play with it?
So yeah, you're talking about my discussion last week when I was suggesting reasons for why just all of a sudden we see more people with autism compared to, you know, years back. Maybe. I mean, I think that somebody, you know, who presented with the characteristics of autism, you know, at the time of, you know, at the time in which like the eugenics movement was very popular and sterilization did occur, certainly those individuals could have become candidates for that procedure. I have not read anything specifically talking about kind of sterilization playing a role. As I mentioned last week, it was mostly like this idea that we had kind of this specific way of classifying people that worked for institutionalization. And so, you know, it didn't really make sense to differentiate in an institution between somebody who had autism or a specific learning disability or other health impairment, right? Because they were kind of being grouped together in kind of, you know, groups that were larger. They were more granular in size. We didn't have to kind of really slice. We didn't have to focus very specifically on kind of like the very subtle learning differences and behavioral manifestations of the conditions, because it just didn't really make much sense in that institutional setting. But yeah, I would imagine that sterilization that probably had at least part to do with it. But certainly in the latter half of the 19th century, we do start seeing schools appearing, serving people with disabilities. And the book talked about these particular groups. Can anyone recall one of these groups? Well, one of the first groups of students with disabilities who had schools designed specifically for them.
Like blind and deaf?
Yeah, visually impaired and hearing impaired. Right. Why do we think that might be?
I think probably, oh, sorry, go ahead.
Go ahead.
Maybe because if someone is blind or deaf, that's, I don't know, maybe like an easier stigma for the rest of society.
Good point.
To get around than like a cognitive disorder?
Right. I mean, they're
just as developing as their peers academically.
right. Probably behaviorally, they are not as, different as would be people without disabilities. Somebody who is visually impaired, somebody who is hearing impaired. Well, chances are they kind of could fit in a little bit better. And the kind of accommodations that were available, technologies that were available to help people who have visual impairment and hearing impairments kind of came about much earlier and were implemented much earlier, right? This was far before we had, intensive behavioral therapy or response to intervention to help students with kind of more subtle like learning differences and learning disabilities, for example. But yeah, so visually impaired, hearing impaired, and then we also had schools for people with physical disabilities as well. So those are kind of the first disability groups that were actually being served by schools, specifically designed to meet their needs. This does not mean that there was any kind of like, state law or federal law put in place that mandated that these services be provided to these individuals. But certainly, these groups kind of formed an impetus, to kind of start advocating and basically getting laws put into place that would support a more comprehensive educational approach that was funded by federal monies or state monies. And then also in the early 19th and 20th centuries, there were also classes, schools that were being developed for students who were considered mentally retarded who were intellectually disabled. And thinking back to our readings, can anyone recall, like, what were some of the characteristics of these schools?
I remember in last week we talked about how some of like probably in the 50s and 60s, kind of like right before the PARC, there were, that the schools had a lot of what exists in like a special school now, there was like medical care on site, there was mental health professionals, which wasn't saying much for the time. But before that, I guess that's not early 20th century. Let's disregard all that. Talk about that later.
But you mentioned schools like having a very specific set of services, right? Yeah. Specialized services. And generally when we talk about a very specialized set of services being, a part of a school, what kind of setting is that? Is that an inclusive setting or a segregated setting?
Segregated.
Yeah, generally segregated. So certainly, these early classes for students with this condition were segregated. Oftentimes, there was little to offer to the children. One could, potentially think of them as more of like just day programs where all the kids just kind of got together and there wasn't any kind of like, rigorous curriculum put into place. There was no individualized or differentiated instruction. These individuals might have just been put into these settings and, tasked with performing menial jobs, whatever those might be. And these kinds of programs still exist. We call them sheltered workshops. Are people familiar with this term of a sheltered workshop? So in the context of, employment, And so when I was working at an employment services agency, we provided employment services to a variety of people with a variety of disabilities. And oftentimes, those who were severely impacted, they would work in a warehouse that we had, okay? And we had a contract with a company that sold tea, like hot tea. Numi, is anyone familiar with the brand Numi, N-U-M-I?
Yes.
Mhm.
Yeah. And so these individuals, their job was to sit at long tables and put tea bags into boxes. So one person would have like the mandarin orange, one person would have the green tea, one person would have the black tea, et cetera, et cetera. And their jobs were to just put 5, whatever flavor they had, put 5 in, pass it on. The next person, put 5 in, pass it on. So there was, an income component to this. These people did get a paycheck, albeit it was based on how fast they worked. So oftentimes they were making sub-minimum wage. But in terms of a generalizable skill, they weren't learning much that was generalizable in that sheltered workshop. And there's a huge movement to shift away from any kind of segregated employment setting for people with disabilities. And it's a contentious debate because, it's my opinion, I speak for myself, but I think that for some people, like that type of setting with a very kind of, low demand, low skill requirement workplace is adequate for some people. Those individuals might not do well working, at a Rite Aid, providing customer service, having to, deal with, any number of difficult and annoying and challenging customers. So it's likely that these kind of early classrooms kind of fit that kind of sheltered workshop model. We'll just put them all together and kind of, give them some very menial things to do, and that's that. But we're not really going to actively try to like push each individual to achieve their highest potential. And lastly, many of these facilities were taught by people who really didn't know what they were doing. They didn't know about best practices for, supporting people with intellectual disabilities, in the classroom. Chances are they were educated to, kind of employ the very kind of standard approach to delivering education. Maybe it wasn't individualized, and chances are it was kind of very low level. So there was just not a lot of room for growth intellectually or personally, maybe socially. Being around a lot of people similar to yourself, certainly social relationships will develop. But that's only kind of one side of the coin when we're talking about educational growth. But there came an event in the 1920s which kind of put a halt on all this. And this event really took a dramatic toll on the economy of the United States. And can anyone think about what this event was? 1929.
Wasn't the Depression, was it?
Great Depression. Right. So we see a drastic reduction in funds available for educating people with disabilities, because the state of our country was basically in turmoil. We needed to kind of get back on our feet before we could really start thinking seriously about rebuilding these educational facilities, and more importantly, bringing into law, safeguards that would, that we have nowadays that would protect the rights of such individuals. But when we get to the kind of end of the 20th century, certainly, people in the educational field are now, you know, kind of invigorating this idea that it is absolutely necessary to meet the educational needs of students with disabilities. So just a very quick overview of kind of, you know, what did special education look like before there was really any such thing as special education law. So we're going to get into some of the evolution of special education law. But first, I just wanted to provide just a quick overview of the American legal system, right? Because that is what is at the foundation of special education law. And if you have any questions or anything, just as always, feel free to ask. So it all starts from the Constitution. It is our primary source of American law. You know, it's the framework from within which our legal system operates. And it's kind of it's the set of checks and balances, you know. So when states create or amend their own constitutions, they are enforceable so long as they don't contradict or limit the rights that are protected under the statutes, regulations, and common laws that are subject to the Constitution as interpreted by the Supreme Court, right? Kind of the Supreme Court's rule, their kind of main task is to size up a case with respect to how it, you know, kind of is interpreted from within the framework of the Constitution. And so remember that education is not mentioned in the Constitution. There was one amendment we talked about during our first meeting that basically didn't speak directly to education, but it spoke to whose responsibility was it to enforce and to establish, you know, school districts or public schooling. Can anyone recall what that amendment was? We talked about two of them last time.
The 10th and the 14th?
Right, the 10th Amendment, right? So basically the 10th Amendment says, you know, we the federal government, we're going to be in charge of some things, and each individual state is going to have the right to kind of dictate how they want to do other things. And education is an example of one of the, you know, kind of concerns of the states that the federal government did not really have their hands in. But it is certainly possible for the federal government to step in, especially when disputes that are arising under state law, specifically those that are depriving individuals of their rights protected under the Constitution. And so, as Nate referred to, that's the 14th Amendment, that, you know, as citizens of the United States, having been born in this country, we are, we have a certain number of inalienable rights that state laws cannot impinge upon. And so when we think about education, and I just kind of flashed you the answer here, what was one of kind of the earliest and most significant situations in which the federal government did step in because state educational laws were in fact infringing on the rights of a certain class of people?
Brown versus Board.
That's it, yeah. Brown versus the Board of Education. And we all know that this is the situation, or the case that basically did away with segregation in the schools based on race. And so according to the 14th Amendment, you know, once a state does create and open a public school, Well, this amendment dictates that it must be made available to all children on an equal basis. And so that's kind of the argument that was taken in the Brown versus Board of Education case. Because indeed, this public school was not open and available to all children on an equal basis. Okay, so just a brief overview of kind of law of the Constitution and how it can get its hands into the state educational system and school district decisions and school boards. So the book talked about 3 different branches of the government, and the first one was the legislative branch. Can anyone remember what the legislative branch is responsible for doing?
Don't they provide the checks and balances over or they create laws?
Yes, sir.
Yeah.
They create the laws. So they might say, we are creating this law, the Education for All Handicapped Children Act, and this means that there can be no discrimination, in the public school system against children with disabilities. So here is a law. And once that bill completes the legislative process, it's signed into law by the chief executive, the president. And now he has the authority to enforce this new statute. And again, statutes, they provide kind of broad directives, right? And I just gave an example of a broad directive. We cannot discriminate against people from different races or people with disabilities in the context of attending public school. And then next we have the executive branch. And does anyone recall the role of the executive branch? Just as a quick hint, Nate said it first before he said the answer to the previous one.
Checks and balances.
Checks and balances, right. They enforce the law by providing details in the form of regulations, right? So these are the people who have like the expertise within the area. Within the area that the kind of law has been passed to protect or to cover. So for example, a statute, it might not have much to say specifically about the content of a curriculum or the length of a school day, but these details are addressed by regulations developed by personnel who are experts in this area. So they would hire, kind of the foremost educational experts in the state to kind of to serve on this executive branch to make sure that the law itself is being fairly administered and equally administered to people throughout the United States. And again, as educators, we tend to be more influenced by regulations than statutes, right? The U.S. Department of Education, its Office of Special Education Programs, and they'll often issue, policy letters, or, they'll talk about, new regulations that have been handed down and interpret them kind of in layman's terms. And the goal of this is to kind of give us as educators the information that we need to know in order to follow the new statutes that are required by the federal law. So a very interconnected system and a very convoluted system, as we'll see, because not only do we have these 3 different branches of government, but we have different types of courts and different levels of courts, and these all factor into cases that have been special education situations that have been brought to the courts. And then lastly, we have common law. Does anyone remember what common law is? This is kind of the lowest level. Basically, common law is when a judge interprets the law by examining issues, right? Because we can have a law developed, but that law is never going to be sufficiently detailed to account for kind of every possible permutation of situation that might fall under that law. And so common law is basically when judges examine issues that may have been overlooked in the legislative or regulatory process, or that may not have been anticipated when statutes were enacted. And so these start to become known as precedents, right? And precedent in the law is kind of what is used to make rulings in cases that happen kind of in the future, but that are related to, you know, a case that happened historically and is considered a precedent, right? All law is built on precedent. When you read these papers that I'm going to send out to you tomorrow, you're going to see that when they're talking about the case that the plaintiff has brought against the defendant, there's going to be a number of, you know, arguments on precedent. Well, according to, you know, Jones versus Oregon County School District, in this matter, this was determined, and then here we have this other case, you know, this decision on the ruling between Oak Tree versus, you know, the Sandy Hook School District. Like, basically all of these previous decisions that were made kind of help serve the foundation for guiding future interpretations and judgments of cases. And so they are rooted in precedent. The proposition that a majority ruling of the highest court in a given jurisdiction over which a court has authority is binding on all lower courts within its jurisdiction. So if you had a very, you know, kind of low state level court make a ruling on a matter maybe related to a least restrictive learning environment, but then you had a case that made it all the way to the United States Supreme Court on a similar matter, well, the decision made by that same Supreme Court is going to completely trump the decision made by the state court. So there is certainly a hierarchy here. And we see that here. The Supreme Court ruling is binding throughout the nation. State high court rulings are binding only in the state. So provided that, you know, if we have kind of a low-level case that never makes it to the Supreme Court, well, the relevant state court rulings within that state are going to be those that serve as the precedent. And then we have a number of different systems. The federal system, we have trial courts in the federal systems. These are referred to as federal district courts. We have state system trial courts that don't really go by a uniform label. Each state has at least one federal court. Some states have, you know, depending on their size, up to 4. And then we have the federal intermediate appellate courts. And so these are called circuit courts of appeal. And there are 13 of these. And they go by a number of names. And we're going to learn about what the role of the appellate court is. And then lastly, we have the highest court of the land, which is the U.S. Supreme Court, where justices are hired for life. Looking at the very kind of basic level, a trial court, a judge and a jury, federal judges in these cases are appointed for life. State courses vary as judges are appointed in some jurisdictions and elected by popular votes in others. So we have this very kind of convoluted legal system that, you know, when a parent or a school district wants to bring a case to trial related to some, aspect or violation of the IDEA. It tends to kind of start at the bottom and work its way up, starting at the state court level and then working its way on up, sometimes to the United States Supreme Court. And again, in these cases, the juries and judges have the role of reviewing case records, of administrative or due process information, other hearings and additional evidence, and hearing testimony of witnesses. And so other than in a few select areas, very few school-related cases are directly under the jurisdiction of a federal court. So there are a few loopholes that they have to jump through before they can proceed to the level of the federal court. And these must satisfy one of two broad categories. And bonus points if anyone can remember what one of these two broad categories is. It was in the first chapter.
Oh, it has to be over $75,000.
Right, and the reason for that being?
Because the federal court system, especially on the high levels, can be really costly.
Yeah.
To do this.
It is a costly machine to put into action. There's this idea of diversity of citizenship. So the plaintiff and the defendant are from two different jurisdictions, and the amount in the controversy must be at least $750,000.
Oh yeah.
And secondly, most important, is equally of importance, is that the dispute must involve a federal question, meaning that the case must be over the interpretation of the U.S. Constitution, federal statutes, federal regulations, or federal crimes. So these are only for the most serious and egregious violations that might occur, at the hands of a Board of Education. So, always in a court case, somebody wins and somebody loses. So certainly if a party is not satisfied with the outcome of their trial, this is where the appellate court comes in. And so they perform a discretionary review. And this consists of about 3 judges, and they review the case for any errors that might have, been undertaken by the trial court. For example, the panels might inquire as to whether or not the court judge properly admitted or excluded evidence from a trial. And so the party that is not satisfied with the ruling of an intermediate appellate court, so let's say the court says, oh, you know what, we looked over your case, and at the state level it was handled appropriately based on our opinions. Well, they can take it to the next level and may seek further discretionary review from the highest court in the jurisdiction, and that's the U.S. Supreme Court. And so they must file a writ of certiorari. In order to grant this writ, at least 4 of the 9 justices must agree to hear an appeal. And not many cases make it to this level, because as you can see here, they receive about 7,000 petitions per year and take on an average of 100 cases. So when we're talking about special education cases, for one to reach this level of the judicial system, it needs to be a very, very serious violation of some aspect of IDEA or the American with Disabilities Act. Okay, so I want to stop there. That was a lot of information about just kind of law. I apologize if it was a bit convoluted, but we're going to move into the history of the equal educational opportunity movement next. We'll talk about the evolution of the IDEA, some of its characteristics, and how it differs from the 504 plan, or Section 504 of the Rehabilitation Act. But before we do that, let's take a quick break and meet back here at 6:06. So we'll take 10 minutes. Okay, I'm gonna stop sharing.
I just wanted to apologize. My internet keeps clicking in and out, so that's why I don't know if it's Eastern Oregon or what's going on, but completely internet keeps fading in and out.
Okay, well, yeah, any aspects that you're missing they're being recorded, so you're good. Okay, so we'll see you back here in 10. Okay, looks like we're all back.
I was able to find the first PowerPoint presentation. It was under files.
Mm-hmm.
So I just was, I didn't find it through the calendar though, but just through files. So if anyone else was looking for it.
Oh yeah, so there's in the files section, I put a folder that says lecture slides, and that's where I'll put all of the PowerPoints in there.
Yeah.
Would you prefer that normally I put them in afterward. Is it helpful for people to have them beforehand, or what would you think? Or does it matter?
It doesn't really matter either way.
Okay. Cool. Well, let us go ahead and get started again. Okay, so now we'll go into a bit more detail into not just the American legislative and judicial system, but specifically law as it relates to educational opportunity, specifically for people with disabilities. So we've talked about this briefly in the past. Well, some states in the mid to late 70s had enacted legislation that provided students with special education services. These were in the minority. And one reason is that there was no federal statute that obligated states to provide comprehensive special education programming. So it was purely in the capacity of the state, each individual state, to determine how they wanted to deal with these situations. And so, as you recall, what was the standard order of business at that point in time in the 70s? So we're talking about like no longer an institutionalization. The institutions have been emptied. This is no longer an approach. Like, what right did many state boards of education have against students with disabilities? To do what to them?
Exclude them.
Simply exclude them from school. Exactly. Not all states were that way, but certainly it was a very common answer to having to deal with students who did not fit into the educational model that that was prevalent and that really is still prevalent in this day and age. To exclude them completely. Of course, the impetus for equal education opportunities for all is based on the Supreme Court's opinion on, we've already heard about this case today, Brown versus the Board of Education. Right, and again, while this case was fully focused on the illegality of segregation based on race in public schools, when you think about it, race is a category, right? It's somewhat of an arbitrary category. Well, disability is also a category. And so basically this ruling really opened up the floodgates for making arguments that, well, race isn't the only category that, we should be, actively fighting against segregation for. So this is really what set the tone for later developments, including those leading to the protection of rights with disabilities. And of course, after this case, many parent advocate groups and other concerned parties really start focusing in on specifics related to disabilities. And again, education is perhaps the most important function of state and local governments, and this is also indicated in the Constitution. Well, the Constitution doesn't say that it's the state's responsibility, and that you guys are going to do it how you want to do it. We do believe that it is perhaps the most important function of a state and local government. While there was some we can consider Brown versus the Board of Education, that ruling conferring some progress kind of in this area of opening up the educational system to broader classes and varieties of people. The rights of people with disabilities continue to be overlooked, which was not unlike the case when we talk about the rights of minorities, African Americans. It was let's see here. Well, one of our other colleagues already referred to this fact that at this time, more than half of the states in the U.S. still had laws that allowed for the legal sterilization of individuals with disabilities. So certainly, we did not make a very progressive jump forward at this point in time. There hadn't been much ground gained, and still, other jurisdictions limited basic other rights for people with disabilities. Can anyone think of one? So there were still states that made it illegal for people with disabilities to do these types of things that you and I take for granted.
There was voting, marrying, and even getting driver's license.
That's it. There you are, Becca. I didn't see down there. Yes. So certainly, this kind of landmark decision in the U.S. Supreme Court that was, kind of pegged as being the catalyst for kind of opening up, all that society had to offer to all people, no matter their creed or their disability status. This certainly was not the case, shortly after this ruling. But as time progressed, we start to see positive gains. Certainly in the 60s, we have a culture that is kind of more progressive and more open-minded and less concerned with the traditional establishment's way of doing things. And so we see, for example, between 1948 and 68, a 20-year period, we go from 12% to 38% of students with disabilities being served by public schools. So that's certainly growth. And then in 1974, just 4 years later, or 6 years later, excuse me, the Federal Bureau for the Education of the Handicapped reported that 78.5% of America's 8.15 million children with disabilities receive some form of public education. Emphasis on some form. So we see that the roughly half that amount receive special education services, or special education and related services. 30.7% received no services. So maybe they were in public schools, but they weren't receiving any services whatsoever related to their disability conditions. And then still we had about 21.5% of students receiving no educational services at all. So certainly not the ideal situation, but an improvement on, historical trends. And then we get into two of the most significant cases that have really formed the foundation for, bringing to the legal forefront, to the public society's forefront, the importance of protecting the rights of students with disabilities. And both these cases were discussed, I wouldn't say at length, but in some amount of detail in our textbook. The first is the Pennsylvania Association for Retarded Children versus Pennsylvania. Does anyone recall the details of that case? What was the plaintiff was Park, and the defendant was the Commonwealth of Pennsylvania. What did they claim? What did they file? What was the crux of their lawsuit? I'm talking about Park.
The age of 8.
Anyone who was mentally retarded was not, they were filing on their behalf, or kids that were between the ages of 6 and 21.
Right. So basically they were filing a suit in a federal trial court against the Commonwealth on behalf of all individuals considered mentally retarded who were between the ages of 6 and 21 and were excluded from public schools, which is a huge case. All individuals who were considered. I mean, this is a number of students. Of course, the defendants, the Commonwealth of Pennsylvania, they had their arguments for justifying these students' exclusion, and they used 4 statutes as their ammunition. Does anyone recall what those 4 statutes are, or at least one of them?
They didn't have a mental age of 8 years old by the time they were 5.
Right, so it had to do with the differential between their chronological age and their mental age. Good. That was one of them. There was another one that was kind of more broad. And it was just kind of based on the Commonwealth's
The psychologist didn't think that they were mentally ready or able to be educated.
Right. Local school boards have any obligation to educate children certified as uneducable and untrainable. And who provided those certifications? Well, psychologists, conducting some form of evaluation. But certainly this is not true. Maybe, no student is completely uneducable or completely untrainable, right? The key here is to find the areas in which they can be educated, in which they can be trained. Yeah, maybe these students are going to be uneducable in, the principles of trigonometry or calculus. Yes, but they're certainly not uneducable or untrainable to learn, basic adaptive living skills that would, help them to become more independent in their lives. So it really kind of depends on, well, within what domains of learning are we arguing that these students were uneducable or untrainable? Okay. And then Mara already mentioned this one. Allowed officials to postpone the admission of children who had not attained a mental age of 5 years old. So no matter what your chronological age, if you are, functioning at an intellectual level below the age of 5, well, then, sorry, you can't come to our schools. Number 3, they relied on a statute that excused children from compulsory attendance if they were found unable to profit from education, and defined compulsory school age as 8 to 17. So if by the age of 8, they were found not to profit from education, well, then they were defined the right to compulsory schooling. Oh, I guess I only had 3. 1, 2, 3. Where I got 1. Okay. So this case was resolved with what is referred to as a consent decree, or just a settlement between the parties that the court later approved. And so kind of the big wins here is that within the Commonwealth of Pennsylvania, no child classified as mentally retarded or who was even thought to be so could be assigned to or excluded from special education without due process. And what does due process mean again?
Right to a fair trial.
That's right. Parents have a right to due process if their child is going to be, excluded from from special education or moved from, one setting to another. And so this meant that placements in regular school classrooms were preferable to ones in the most restrictive settings for children with disabilities, and that these children, I was going to sneeze, neither could be denied admission to public schools nor be subjected to changes in educational placement unless they, through their parents, receive procedural due process. So this is kind of like one of the conceptual foundations of IDEA, right? The safeguards, one of the major safeguards of IDEA is this idea of due process. The school districts can't just go around moving students from one placement to another without going through a very formalized process. The court also added that all children can learn in school settings. So this speaks to kind of this idea that I made, this point that I made earlier. It just depends on what is being taught in the school setting. And so certainly a school setting should be, one in which we provide learning opportunities for a broad range of individuals with varying levels of mental and intellectual capacity. And lastly, the Commonwealth was obligated to provide each student who is considered mentally retarded with a free, appropriate public education along with training programs appropriate to their capacities. So now we're getting into kind of this like specialized, instruction that is more, appropriately focused to addressing the learning needs and differences that this particular group of students possessed. And then lastly, we had Mills versus the Board of Education of the District of Columbia. So this was another big one. Does anyone remember the details of this case?
Most of the kids were minorities with some kind of behavior problems, issues, and
So basically, a group of 7 parents filed a class action suit in a federal trial court on behalf of about 18,000 students with disabilities who were not receiving programs of specialized education. And Mara, as you mentioned, that most of them were minorities, classified as having behavior problems, being mentally retarded, emotionally disturbed, hyperactive. And one could possibly make the argument that these diagnoses were based on the results of biased standardized tests, right? Tests that were normed on samples of upper middle class Caucasian students. And so when you give these types of assessments to students from minority groups, well, they don't have the same cultural or the same cultural upbringings that this kind of norm sample did. So this is kind of one way that minority groups are often overclassified as being as requiring special education, just because of the nature of these types of tests. And so basically, the Board of Education argued that it didn't have enough money to pay for all these students. That was their excuse. But of course, the court said that's not okay. Just because you don't have enough money does not mean that you get to deny services to children with disabilities. And in fact, if we look at point 3 here, the court required an equitable expenditure of funds so that all students received an education consistent with their needs and abilities. So, they can no longer say, oh, these students are too expensive to serve, so we're just not going to, educate them in our school districts. No, you have to use that money in an equitable way to provide educational services for students both in and outside of special education within your school district. And so, yeah, there were just kind of two differences between these two decisions. The Park decision was essentially an agreement, a consent decree, whereas the Mills decision was on the record, meaning that the court reached a judgment after a trial on the merits of the dispute. And so just kind of, well, they were both significant. I think the Mills decision is kind of the more authoritative one because it did make it up to one of the higher levels of the judicial system. And so both of these cases, as I already mentioned, were precursors to the IDEA. The Park case helped to establish the conceptual basis for what developed into the IDEA. Basically that, school districts cannot deny students with disabilities. They are entitled to free and appropriate public educations. The Mills case kind of fleshed out some of the very elaborate due process procedures that are still actually, part of the IDEA's regulations. And also it said that since the Mills case originated in DC, it was kind of a much more significant influence on moving federal lawmakers to take steps necessary to ensure adequate protection of children with disabilities. When they adopted Section 504 and then the IDEA. So there were other cases, but these are just two of the biggies. As we progress through the course, we'll talk about kind of some of the other court decisions that were made kind of in this same time frame, but that were kind of focused on kind of different, they inform different aspects of what would now become IDEA. So one of them is about evaluation and the use of bias tests. So we'll look into a few more of those as we delve deeper into the details of the IDEA. Okay, so now we're going to look at the legislative mandates of the IDEA, or I'm sorry, of the United States government. So these are basically the four sets of laws that are informing special education. And so who can think of one? We've just spent a lot of time talking about it.
I think I highlighted it.
IDEA.
Yep.
Americans with Disabilities.
Yep. And there's one more too.
Section 504, is that part of that?
Uh-huh.
No Child Left Behind.
Right, but the No Child Left Behind has changed. It's no longer called the NCLB. I think it's the
Every Student Succeeds Act.
Yep. Every Student Succeeds Act. Yes. But I do not have that one on here. So let's take a quick look at the IDEA. Here we see all of the public laws that eventually culminated into the Individuals with Disabilities Education Improvement Act of 2004. So basically, you know, we have in 1970 the Education of the Handicapped Act, and then we have amendments made to that 4 years later, and then we have in 75 the Education of All Handicapped Children Act, 86 the Handicapped Children's Protection Act of that year. We have the amendments made in 1986, and then it's in 1990 when the IDEA first comes into fruition. And in 97 and 2004, we have amendments made to the original statutes set forth in the IDEA. So about 38 years at this point, if we consider, if we take it to our current day and age, of basically special education law that has evolved to better regulate and protect the rights of students with disabilities and learning differences. So this was the first one, 1975, Public Law 94-142, the 142nd piece of legislation introduced during the 94th Congress. It set forth basically 4 guidelines for the education of students with disabilities. I'd like to ask one of you to think back to your reading and try to identify what these are. One of them is to assure that all children with disabilities have something. And it's language that's used in IDEA.
Free and appropriate public education.
You got it. And related services designed to meet those needs. The second one is also a part of, has been retained in IDEA. And it has to do with like the procedural safeguards It protects a children. It protects a child's and a parent's.
Is it the IEP?
Not the IEP, but their rights.
Due
Their
process.
rights?
Their due process. Yeah, due process is essentially a means by
Procedural
which.
safeguards?
What's that?
The safeguards?
Yeah. So yeah, basically, due process is one of the safeguards that protects the rights of children with disabilities and their parents. So those are all right. The third factor is that Public Law 94-142 assisted states and localities to provide for the education of all children with disabilities. So that was in the form of monetary support, that was in the form of education, and then there was a fourth. Assess and assure the effectiveness of efforts. So this is also speaking to efforts to better educate and to better improve the capacities of educators working to educate children with disabilities. There's one thing missing here that we're all very familiar with from the IDEA. So we see that we see the free and appropriate public education. But normally, where is the free and appropriate public education supposed to occur?
The least restricted environment.
Yeah. At least based on these high-level bullet points, kind of the least restrictive environment wasn't one of kind of the main, basically, points of focus of PL 94-142. So we have revisions made in '86. In 1990, it was amended even further and then renamed the Individuals with Disabilities Education Act. And so one of the big changes at this point in time were initiatives for transition planning. And these were realized by the requirement of including individualized transition plans as part of IEPs. 97, there were further revisions. And interestingly, in 1997, they changed the age at which transition should begin from 16 to 14. So for a brief amount of time, an ITP needed to be put in place beginning at the age 14. But as we'll see in the 2004 amendments, the Individuals with Disabilities Education Improvement Act, the age goes back up to 16. Another change here was had to do with dealing with challenging behavior in the classroom. So here's where we are introduced to the introduction of functional behavior assessments, and including as IEP goals, measurable behavioral goals that are based on those FBAs, and that also include written behavioral intervention plans. So a very kind of formalized approach to dealing with challenging classroom behavior is introduced at this time.
I have a question.
Yeah.
So I know that I have FBAs and BIPs in existing IEPs, and I've written a few of them. It's later in this program, not like this semester, but like in other semesters. Is that something that they're going to go over, or is that expected that the district will train teachers how to do?
So to conduct a formal behavioral intervention plan or a functional behavior assessment?
Yeah, I've done a few, but with the assistance of a school psychologist and my TOSA and this and that, but I'm not great at them. And so is part of this curriculum learning how to put those together.
Well, yeah, so next term, all of our classes focus on assessment. So we'll certainly address BIPs and FBAs during that term. But in terms of like fleshing out like a very formalized functional behavior assessment, like we're not going to necessarily go through all the steps, but one of the projects will be that you get to kind of choose what type of assessment you would like to implement and what kind of plan you would like to write up based on the outcomes of that assessment. So if, you know, the FBA or a BIP is, you know, one option that you're interested in, you would certainly have the freedom to do that for your assignment. And we will go over them, like, you know, we'll do readings related to them. But I mean, in reality, like, crafting effective FBAs and BIPs could take an entire class.
Yeah.
And you do see these, I mean, you know, like Masters of Science programs and special education do have classes, you know, entire 10-week classes just on those topics. So unfortunately, kind of given our limitation of time, we can't go into that much depth, but I will certainly make sure to include, you know, reading materials and activities on those topics, because I think they are important.
I'm kind of curious if anybody else has written them, has any experience with them in class.
I have.
Cool.
We can talk about that sometime.
Sure, yeah, that'd be cool.
I actually just had a BSP meeting 15 minutes before I logged on. So,
I feel like there's a few coming my way.
yeah, I feel like they happen at the beginning of the school year a lot.
Yeah.
Yeah.
Cool.
So in 2004 is when we had the IDEIA written into law by George W. Bush. And a number of revisions were implemented. I won't go through all of them, but I certainly will give you the categories in which a lot of these revisions fall under. So there was a huge emphasis on the use of research-based interventions. Certainly in the context of, you know, working on the development of, not development, but helping students reach IEP goals and benchmarks. As you recall, a huge part of the No Child Left Behind Act was the use of research-based interventions in the classroom. And so and since Bush also signed that into law, we see some carryover. There are changes to the IEP. Like one change was that an IEP team member could be excused if during a particular IEP meeting, that person's kind of area wasn't going to be discussed. And that was allowed as long as the teacher or the school district approved it and the parents improved it. Changes to due process. Changes to student discipline. A big change here was that the burden, so as you're well aware of, if it can be proved that a behavior or a situation in the classroom that is going to result in a suspension is actually a manifestation of the child's disability, well then that suspension does not need to happen. Those are called manifestation determination meetings. And so in this set of revisions, kind of the burden of proof was put on the parent to provide evidence that it was not just their kid acting up. This was actually a manifestation of the student's disability. Okay, moving on. The IDEA has 4 basic statutory requirements. The student must be aged between the ages of 3 and 21. 3 is when the kid enters the school district. 21 is when a student will age out of the school district. And so after that, IDEA becomes a service that is no longer available to a student. Must have a specifically identified disability. How many categories of disability does IDEA recognize? Does anyone know?
13.
13, that's right. 13 categories. So it must be one of those 13. The nature of the disability must be such that it requires special education for the student to make educational gains. And 4th, the student must be in need of related services when necessary to benefit from special education. So not all students with an IEP require, related services or technologies, but certainly this is one of the requirements if those services are necessary. The IDEA must require specially designed instruction to receive the free appropriate public education in the least restrictive environment, conforming to the individualized learning goals formally set forth in the IEP. The IDEA includes an elaborate system of procedural safeguards, and we'll talk about what these are in more depth as we move forward in class. And again, these are to protect the rights of children and parents. And we talked about this first point here. District personnel must provide written notice and obtain parental consent prior to evaluating a child. If a district feels that a child needs to be evaluated, but the parent refuses the evaluation, well, the district does have the right to challenge that parent's position and take them to court about it. They must provide written notice and also obtain parental consent for making initial placements, initiating changements in placements. Parents must be allowed to participate in IEPs and placement decision making. And then the annual review of the status of students, and also a reevaluation at least every 3 years. So the goal here being that everyone's informed and that as a child develops, the plan that is guiding that child's intellectual growth is keeping pace with the child and is not becoming stagnant. Okay, so now we're going to shift gears. We're going to talk a bit about the 504 because there are some differences. There are some similarities, but there are certainly some big differences between these two, legislative mandates for providing students with disabilities support in the classroom. And so again, Section 504, predicated on an institution's receipt of federal financial assistance. So in theory, if a school did not receive any federal support, well, then they wouldn't have to offer services under the 504 plan. This is only for schools and institutions that do receive that kind of assistance. But most public schools, many private schools do actually receive federal assistance. And so again, the second point, it offers broad-based protection to individuals under the more amorphous concept of impairment rather than disability. So certainly disabilities are characterized by a variety of different impairments. So now we're just talking about the impairments. We can have an impairment present without the presence of, you know, the diagnosis of a disability. And so here's a definition of an individual with a disability according to this Section 504. The person has a physical or mental impairment which substantially limits one or more of that person's major life activities. Has a record of such impairment. And is regarded as having such an impairment. So that's interesting. You have a record of an impairment, but you must also be regarded as having such an impairment. I find that language interesting. Does anyone else have any thoughts on what that's communicating? Should not a record of the impairment be enough?
Isn't the regarded, doesn't that have to do with like the parents have to recognize it and bring it up to the schools?
Right.
So regarded would be they're regarding their kid has the impairment.
Right. So it's up to the parent and the student to get the necessary records and then to present that case to the school district. So it's kind of like the same situation when, you know, a kid transitions out of high school and goes to college. It is on the parent and the child to provide this documentation. Physical or mental impairments. I mean, we have a whole laundry list of potential situations, potential conditions that would, you know, technically qualify somebody for services under Section 504. Everything from anatomical loss. Someone had mentioned like breaking a leg and possibly be, you know, qualified for a temporary 504. I don't need to go through all of these, but as you can see, there's a whole broad range of physical impairments. And then we have some mental impairments as well. Mental retardation, organic brain syndrome, emotional or mental illness, specific learning disorders. So again, we do have some disability language here. But it is possible for a student, for an individual to, you know, show some characteristics of a specific learning disorder, but not to meet the full diagnostic criteria for it. So that's kind of like what Section 504, in my opinion, is the main role that it's serving. So these students who, you know, who certainly have these differences or these challenges, but do not, you know, present with the required number or combination thereof to receive an official diagnosis.
I think 504 reminded me of like, so I have ADHD, and when I was in high school, they kept asking like, oh, do you want to get evaluated? They would ask my parents, and I was like, no, I don't want to be in a special class. And even if I would have been evaluated, it would be, I was like honors tag, whatever, straight A student, so they probably wouldn't have put me in like a resource class or, you know, a behavior class. I probably would have just ended up with 504 saying I need a little extra time taking tests because I can't focus when I'm rushed. And so when I was reading about the IDEA, it was saying that like I think the third one was that you have to, so it's like you qualify, you have a diagnosis, you have all these things, but you also had to be in need of special education, like a not necessarily a separate class, but like I wouldn't have needed that. I would have just needed certain accommodations for my regular classes or my honors classes. Yeah,
no, that you probably definitely would have. I mean, I think of just a very common accommodation through Section 504 is extended test taking times, maybe, you know,
in a quiet space.
The opportunity to take your test in a quiet setting, exactly. Extended deadlines for assignments.
Yeah.
Stuff like that. You know, maybe access to notes before, you know, class so that you can review them and be better prepared to, you know, pay attention and, you know, participate in discussion. So in order to have a record of impairment, an individual must have a history of or been identified as having a mental or physical impairment that substantially limits one or two major life activities. So here's where we get into the regarded. Individuals who are regarded as having impairments are those who have a physical or mental impairment that does not substantially limit major activities, but that instead is treated by a recipient as constituting such a limitation. That's interesting language. Treated by a recipient as constituting such a major. Who is the recipient?
The person that's receiving federal funds and administering the services.
Right. So you might have a situation that does not substantially limit your major activities, but the school thinks that maybe you would benefit from, like, for example, having a note taker or something like that. So they're kind of treating you as constituting the limitation. A physical or mental impairment that substantially limits major activities only as a result of the attitudes of others towards such impairment. Another interesting caveat to the Section 504. So if other people treat you as if you have a physical or mental impairment, then you technically could qualify for services under Section 504. Does anyone else read that differently? Negative, okay. Or none of the impairments, but is treated by a recipient as having such an impairment. So it seems like that the recipient of the federal funds, if they believe that you are performing substandard in some way, that they can request to have accommodations put into place for you to improve your performance, which is kind of how I read this section of it, which I find is interesting. Much, much different than IDEA. Go ahead.
How I look at it is kind of like, say, there's a student who maybe has some behavior problems, but not identified. And so they have someone who pushes in for a little bit during the day or pulls them out for a break.
Right.
So, they're identifying that there is a problem or there's too much stimulus in the class. So they get to go out for like a brain break, basically, or. Right.
But it's not substantially limiting major activities.
Yeah. I don't know.
That's the thing. A lot of the language in these, statutes is very vague. It would be helpful if things were just kind of more straightforward. But listen, we've reached our deadline here. I had just like 8 more slides to go, talking a bit more about Section 504. But what I'll do is I will put them on Canvas for you all to look at. And what I'm going to do tomorrow is I'll send out the papers that I found for the case law assignment. I've done my best to keep them, short. Most of them are, in the 25 to 27 page range. But as you'll notice, if you've ever read like a legal brief, they're like wide margins, so very narrow text and like lots of spacing, big font. And I found examples that aren't like so kind of like esoteric that they're going to be very hard to interpret. So I'm hoping it'll be a good activity, and I'm just going to just kind of send you each one randomly because I was considering putting them out there and letting you choose, but if 5 people choose the same one, well then we're just going to hear the same presentation 5 times in a row. And I think it'll be more fruitful to just hear like about a variety of different cases. So I'll email those to you on an individual basis tomorrow, okay? And
Woo!
what?
Said woohoo!
Ooh, good. That's it. Excitement. Excellent. Well, thank you, everyone. And I will be seeing you all tomorrow at 5 o'clock.
See ya. Have
All
a good
right.
night.
Bye-bye.